what 11073 did was open a door for people to bring in that evidence and show that they would not have likely been convicted had this been shown at the time of their trial. There haven't been any cases where there's been relief granted based on 11073 where there's been a death penalty, which is astounding considering the fact that many people across the country have been exonerated from death rows based on faulty science.
Welcome to this new episode of Death Row Stories. We trust science to tell us the truth. In courtrooms across America, scientific evidence decides who is guilty, who is not guilty, and sometimes who lives or dies. But what happens when that science is wrong? For decades, techniques like blood stain pattern analysis, arson investigation, and even testimony under hypnosis were treated as hard science across US courts. But today we know that some of these techniques, or at least the way they were used in the past, are not always reliable. Some have even been called junk science. So the science has changed, but not the verdicts. And some people have been sent to prison, to death row, or even executed because of flawed forensic evidence. In Texas, lawmakers created a junk science law to help those convicted with flawed evidence get a new trial. But there's a problem. The law doesn't work as promised. In this episode, I speak again with Estelle Hebron-Jones. You might remember I interviewed her in one of the first episodes of Death Row Stories about racism in the implementation of the death penalty. In July 2024, she released a new report with the Texas Defender Service again. In it, she exposes why the Texas junk science law isn't living up to its promise and what could be done to finally fix it.
My name is Estelle Hebron-Jones, and I'm an attorney at Texas Defender Service and Director of Special Projects. And over 1.5 years, I led our report called An Unfulfilled Promise, examining the efficacy of 11073, the critical examination of Texas's junk science law.
Thank you very much for being here, Estelle. In 2013, Texas became the first state to have a specific legal pathway for people to overturn their convictions based on false forensic science. What is the big change in that law?
Well, before 2013, when this law was passed, 11073, also known as the junk science law, people could go to the court to petition for relief, saying that they were innocent, that there was new evidence in their case. But when it came to cases of false or unreliable science, they couldn't really do that because the new evidence wasn't necessarily unavailable at their trial. And also, when there was either a change in the science or someone had changed their opinion, it didn't necessarily mean that they would be able to show that they were actually innocent in the legal sense. And so what 11073 did was open a door for people to bring in that evidence and show that they would not have likely been convicted had this been shown at the time of their trial.
How exactly does it work?
So when someone has evidence of either change science, a change expert opinion, something like that, that relates to forensic science in their case, they would file an 11073 petition to the court in which they were convicted, and that court will then decide based on the petition and then any additional evidence collected either through hearings or through affidavits or any other kind of evidence collecting process, whether that person should get relief, and they put together findings of fact and conclusions of law. And that goes to the Court of Criminal Appeals, who makes the final decision on whether, with all those facts that have been presented, whether or not it would have been likely that the person would have been convicted had the jury or jury and the court known this evidence at the time of the trial.
How many cases has the CCA decided?
In our report, we looked at 74 cases that had been filed and decided by the Court of Criminal Appeals. And so these are cases that have gone through the entire process. Now these are cases from September 2013 up through the end of December 2023. So there are cases that are pending and have been cited since then that aren't included in our numbers. There are also some cases where cases have been expunged, and so they're not included in the public record. There are also cases where people may have claimed to be filing 11073 or junk science claims, but in substance weren't those claims. And there is the possibility that there are cases that may not have been docketed by courts as 11073 claims. And so this 74 number includes those cases that have gone through the complete process. Yet we acknowledge there's some cases that might not be included for various reasons, but this is a number that other groups that track this as well, that they also agree with.
How do you explain why Texas was so far ahead on this matter?
It started with a few different things that occurred. One of them being, for example, the Houston Crime Lab, and it having to close due to an audit which uncovered contamination, mistake-ridden work, untrained staff, leading there to be the closure of the DNA and serology sections of that lab. And along with that, there were several cases which raised this issue of unreliable science and how it affected cases, yet there was no legal pathway for people to pursue their claims if this was in fact, if this false or unreliable science was in fact present in their cases.
It ended up with the lab closing?
Yes, and the lab closed, and that was in November 2002. So it was, quite a few years before this law had been passed that we were starting to see that there were issues going on with forensics in Texas.
And a death row case also drew attention. It's the Cameron Todd Willingham case, right?
Yes, Cameron Todd Willingham was a case where he was convicted of capital murder. It was an arson case, and there were a lot of questions about the science used to determine whether the fire was in fact arson. And so, unfortunately, Mr. Willingham was executed, and since then, it's still been widely believed that he was in fact innocent, and if he had a way to present this evidence, that he probably would have gotten relief and been released.
And another case led the state to amend the junk science law.
Yes, Neil Hampton Robbins, in fact, he went to the CCA twice, bringing this false, unreliable science in his case, it was a changed expert opinion. So his first case, in fact, is something that led the legislature to create this law, 11073. And then when Mr. Robbins was granted relief, the court also recognized that there needed to be a way for people to bring claims when an expert has changed their opinion in a case. And so the law was amended to clarify that that's also something that can be brought to court, a changed expert opinion, along with false or unreliable science.
How does this law work, and how did you assess its efficacy?
11073, the junk science law, it works similarly to the other post-conviction laws that exist, except it just relates to false or unreliable science. And so it would follow a similar process, and the convicting court issues its findings, and the Court of Criminal Appeals makes the final decision. To examine these cases, we pulled the applications that were filed to the convicting courts. We pulled the opinions from the CCA, either granting relief, denying relief, or dismissing cases for procedural bars. And so we documented the types of offenses the types of evidence that were raised in the courts, whether there was an evidentiary hearing in these cases, and we looked at the length of the opinions that the CCA delivered, whether that was granting, denying, or dismissing these cases, and we used that to see what was happening what had happened with this law, to see whether people were actually getting relief, whether people were getting relief on all types of science, and whether people were being prevented by procedural bars from having their claims heard on the merits, meaning that the actual evidence was reviewed by the court in a case. And through that's how we determined whether it's been working. And from that, we observed that the law wasn't fulfilling the promise that the legislature had intended.
Yeah, we're going to look into that. Let's go over your 5 points of discovery. Finding number 1, the Court of Criminal Appeals, CCA, is asking from the convicted people more than the law itself requires.
What we found is that in the cases where people have been granted relief, the kind of language that was used suggested that they put a really big emphasis on those cases where people could be more likely shown to be actually innocent under the actual legal innocence standard. And so it's not to say that people who aren't innocent shouldn't that we think that they should be granted relief. It's more to recognize the fact that actual innocence under the legal standard, meaning that no one would ever find guilt in a case, is a very, very difficult standard to achieve. And so what we found is that the CCA seems to only or mostly grants relief in these cases where it's usually a case where there's like DNA evidence and people can eliminate their guilt more likely because they can point to an alternate perpetrator. However, in cases of unreliable science, this isn't always going to be the case that you can point to an alternate perpetrator. If it's only people who can fit that actual innocence standard, then it means that the law isn't really fulfilling what it was supposed to do, because there already exists a mechanism or a way for people to go to the court if they are actually innocent, whether it's due to false science or any other type of a new evidence that's in a case.
One of your recommendations is that the CCA stop asking for so much. So here, you're not asking for a change in the law, right?
Yeah, no, we believe that, and as what you've heard from legislators recently, we believe that what they intended is not necessarily for people have to meet that actual innocent standard. And so what we would like is for the CCA to consider cases under in the way that law is written. But it could mean that if the law were amended, it could be clarified to ensure that the CCA is only following the law as it's written and not applying that higher standard that usually comes up in other types of post-conviction cases.
Finding number 2 is that the CCA grants relief almost only when new DNA evidence is presented.
Yes. And, most of the cases that are filed do relate to DNA evidence, and that makes sense because they're going to be cases where it wasn't available at the time of their trial or processes have changed. That's definitely true. But this this emphasis on DNA cases is showing that it goes back to that issue of them looking at actual innocence. DNA cases are easier, I think, to grant relief in because, again, you can eliminate people or identify someone else as a perpetrator. But when we look at the legislative history of the junk science law, you can see that what the legislators wanted was for all types of science to be considered. They wanted something that would be able to catch all those different types of cases. And like you see in Cameron Todd Willingham's case, for example, that was an arson case. It's it's like you can't necessarily identify a perpetrator, or it it's not as cut and dry maybe as DNA evidence, but it's just as valid that there can be questions in those types of cases as well.
In your report, you name some of the fields where scientists today have a different view on the evidence than a few years ago or sometimes decades ago.
In the report, we document all the different types of evidence that have been raised, and so it also includes bite mark evidence, biomechanics, shaken baby syndrome, ballistics, even hypnosis. So even disciplines that it's even questionable whether they are in fact science. And again, in most of those, their relief hasn't been granted. And on most of those, I believe that there hasn't even been a really true look at the merits of those cases.
Finding number 3 deals with the death penalty.
Yes, and in looking at all the cases that have been filed and decided by the CCA, there haven't been any cases where there's been relief granted based on 11073 where there's been a death penalty, which is astounding considering the fact that many people have across the country have been exonerated from death rows based on faulty science. And so while we can't say what should or should not be granted, it is concerning that there haven't been any capital cases where there's been relief. And this trend sort of with how the Court of Criminal Appeals treat capital cases, sometimes there is a different, they treat them differently and are, I think, much more stringent with these cases. And like one example of that being like shaken baby syndrome. Recently has been the Roberson case where he was denied relief, but probably in September, August 2024, there was a non-capital shaken baby syndrome case where the Court of Criminal Appeals did grant relief. That's not included in our report because it comes after that time period, but you can see how capital cases are treated. There's evidence that capital cases are treated differently.
And why would they treat capital cases differently?
Capital cases are they're the most severely punished cases. They're cases that have involved a lot of time and resources. There's a really big emphasis on finality in capital cases and not wanting to have to go back through the process all over again, both for resources for victims, family members. With capital cases, it takes a lot more to get relief than non-capital cases.
Let's discuss a very surprising decision from the CCA concerning a death row case. A death row case you know very well, the one of Rodney Escobar.
In Mr. Escobar's case, he presented an 11073 claim citing several areas of unreliable science. One of the biggest ones relating to DNA evidence, and in particular how the Austin crime lab handled that evidence. Similarly, they had their own, similar to Houston, they had their own scandal. And in his case, that evidence was presented. There was an evidentiary hearing in the convicting court, and that court issued findings of fact and recommendations recommending relief that went to the Court of Criminal Appeals. And while typically the Court of Criminal Appeals takes the advice of the convicting court, in Mr. Escobar's case, the CCA did not adopt those recommendations and denied him relief. And in fact, in his case, since that post-conviction application was filed, the Travis County DA's office, which prosecuted him, in fact, has agreed with those findings of the convicting court and does believe that Mr. Escobar should be granted relief. And despite all of that, the Court of Criminal Appeals has resisted granting him relief.
Finding number 4 is that people without a lawyer have very little chance of succeeding in their relief application.
Yes. So people who are representing themselves, we also call them pro se applicants, generally across the board have difficulty getting heard in court in any stage. But with these cases, it's particularly important for someone to have counsel because you're dealing with a complex legal process, but also you're dealing with science issues. And this involves for you to file an application that's actually going to be looked at and considered by a court. You would probably also want to have expert affidavits with your application. You'd want to have some sort of explanation of the science. And often, most of the time, if you are filing an application yourself, you're currently incarcerated, so you don't have access to a lot of resources. And so pro se applicants, their cases are often ignored, not considered very thoroughly. I think that the fact that they don't have attorneys, they're taking advantage of in that process. And there's only been one person who's filed an application pro se who has been granted relief. And that person he filed it when he was released. And so there's evidence there of the fact that just being incarcerated while trying to file these applications really puts you in a very unbalanced, unfair position.
But can we really blame the CCA for that? Because it's a pretty high court. It's not surprising to me that it's hard, yes, to file a case.
I think the CCA could do more to assist pro se applicants. So, for example, if somebody files an application and they file it in the trial court and it goes up to the CCA and the CCA says that there should be more fact development, the CCA, usually in their orders, they'll say the person should be appointed an attorney if there's going to be an evidentiary hearing. But evidentiary hearings aren't the only way that you can do fact development. It can also be documentary. So getting expert reports or affidavits. And I think even in those situations, people should still have the opportunity to have attorneys appointed. I've seen cases where this Court of Criminal Appeals has said, given this language saying an attorney should be appointed if there's an evidentiary hearing, the convicting court decides to just collect documentary evidence, and the person has asked for an attorney to be appointed, and that's been ignored for much of the process. And so I think the Court of Criminal Appeals, together with the trial courts, convicting courts where the applications originally are filed, can all do more to appoint attorneys in these cases. They can appoint them during fact development, but even earlier, once a person has filed something, it would make the process a lot more fair and legitimate if someone could have an attorney appointed much earlier process.
Yes, it's one of your recommendations is to help these people obtain a lawyer.
Yeah, exactly. If people are appointed attorneys, even if it's immediately after filing an application, which has followed all of the rules, just having an attorney being able to assist the person with complying, making sure that they have fully briefed as much as they can, brief their issues as much as they can, would ensure or assist a lot of people who have potentially meritorious claims but don't know how to navigate the system.
Because if the request that is done without a lawyer is denied, the people cannot file a new claim for the same reasons, right?
You can try to submit a subsequent application, what they call it, a second one, but there are barriers to that, which, if you've already filed something with those claims before, it'd be very, very likely barred. So yeah, trying to file again after you filed the first time is a huge obstacle to getting review in the future.
In your report, you mentioned a heartbreaking case of an inmate that just writes a little note saying, "Please do DNA tests. They were not available at the time I was convicted for a rape."
Yes, and that's an example of how the process is not, if you are, for people who aren't lawyers, the process can be difficult to understand. And even in that case, it might, his 11073 may be useful to him in the future, but even just getting that preliminary DNA testing, you see that that's something that he wanted, wants, but didn't really know how to access that for DNA testing. There's another kind of petition. It's called Chapter 64, which can get you started on that process of getting DNA evidence examined. But you can see how without an attorney, he doesn't know how to follow that process. And that was a case where, like others, where pro se, dismissed without any review, and no one is there to give him any guidance on how to actually get this DNA evidence examined in his case, and then potentially file an 11073 application in the future.
That's sad. Finding number 5 is that there are too many procedural bars. Is the issue here with the CCA, or is it the junk science law that is poorly written?
So procedural bars exist to prevent people from abusing the system. So you're not filing, the same thing over and over again, or filing things that aren't meritorious. But what we observed in looking at the cases that have been filed is that there are cases that we believe are meritorious, yet because of a procedural bar, they don't have those claims reviewed. And we see this especially with the death penalty cases. I can't say whether it is written poorly. It's more how it is applied. And what we see is that it's that when we see the CCA dismissing claims saying that they are procedurally barred, we don't even know exactly on what basis they are making this determination. And there are cases that we've seen where it doesn't appear that the evidence was available at the time of their trial or at the time of the prior filing, yet the CCA dismisses it, saying that it's procedurally barred without much else there. And so it's from what us practitioners see, it seems to be more a case of how the CCA is making those evaluations.
You mentioned the procedural bar of an in-row inmate. His case relies entirely on the testimony of a forensic pathologist, and after the conviction, he changed his mind. Today, the man is still on death row.
Yes. In DeMontreal Miller's case, the forensic pathologist changed their opinion about the cause of death and the time dating of the victim's death. And the Court of Criminal Appeals, despite there being a really strong brief filed in the case, dismissed it as procedurally barred, meaning that no court really reviewed the merits in the case. And this is something that especially happens in death penalty cases, because usually somebody would have already filed a post-conviction application. So a lot of these junk science cases that are filed, they are usually subsequent applications, and so they have to meet this higher standard of being reviewable. But Mr. Miller's case is an example of one where someone has presented some very strong claims, both strongly indicating that the evidence was unreliable, indicating that the opinion has changed, and that would affect the outcome of the trial. Yet here we see procedural bars prevent the evidence from even being considered.
How can you explain that here?
Well, that's the thing. It's difficult. You really can't explain it because the CCA's opinions don't include very much detail about why they are dismissing something. Simply, they say this has been barred, fails to meet the requirements of filing a subsequent application. So we can't say why exactly. We can make some guesses about how they reached those conclusions, but we don't know.
They don't have to give more details, even in such a case, a procedural bar.
No, they don't have to. There's no law that indicates what they have to write, the substance, the amount of explanation they need to give when they're dismissing or denying something. So it's really up to them to give as much or as we see, as little as they want.
The case of Rodney Reed is quite similar. The state's expert changed his testimony 18 years after Reed was convicted, and Reed is still on death row today. However, the CCA imposed a procedural bar.
Yes. In Mr. Reed's case, the expert changed his opinion, saying that what was once seen as a sexual assault was a consensual encounter, which really changes the atmosphere of the entire offense, among other factors in his case too that are really compelling. But again, the CCA dismissed the applications. He's filed multiple applications relating to junk science, but the CCA again didn't provide a specific reason for why his claims were barred.
Once denied, do these claims have a pathway to federal court?
No. So Texas's junk science law it's a state law, and it doesn't rely on any constitutional law, which is what you need to be able to take your claims to federal court. Now, sometimes you can mix these claims with a federal claim. So whether that's a false testimony claim, it might be related to a Brady claim, meaning that the prosecution didn't disclose evidence that they should have. But that, again, is not always going to be the case. And so without that connection to some sort of constitutional provision or a Supreme Court case, you're unable to take these claims to federal court on their own.
Your report also mentions the case of Robert Roberson, who was accused of killing his baby girl. The state claims she died of shaken baby syndrome. In 2023, the CCA denied his claims. Can you tell us about this case?
Yes. So Mr. Roberson, he was convicted based on the shaken baby hypothesis. It's something that's been discredited since the time of his trial. Yet there are differing opinions on whether the state later on has said that, well, actually it wasn't based on shaken baby syndrome, based on these other factors. But when you actually look at the trial transcript, you can see that the state really relied on this. And in fact, his own attorneys relied on it at that time because it was such an accepted theory. And since then, many scientists and doctors have discredited it, saying that the symptoms that they used to identify as if these three things were present, meaning it equals shaken baby syndrome, they've now come to find that that is not in fact the case. And in the case of Mr. Roberson, there were other factors that influenced or made some of these symptoms present in the case, which is why the opinions have changed there. And so Mr. Roberson was, when he presented these to the court to the convicting court and the Court of Criminal Appeals, yet he was denied by the courts. There was an evidentiary hearing in the convicting court, and there was lots of new evidence produced and introduced into the record, but the court did not seem to really take in that evidence, and instead of adopting or using some of the findings written by his trial team, they fully adopted the findings and recommendations almost fully adopted the findings and recommendations written by the state, which really ignored the huge volume of evidence that came out in the evidentiary hearing and really turned away from the clear shaken baby syndrome hypothesis that was relied on at trial, and later on in these findings of fact made it appear as if shaken baby syndrome wasn't in fact a significant part of the way that guilt was found. And so the trial court adopted those states' findings almost word for word, and then the CCA, as it usually does, adopts recommendations of the trial court. It denied Mr. Roberson's claims.
So here it's not the law that is a problem, it's more the way it's applied by the different courts, right?
Yes, exactly. In Mr. Roberson's case, if you look at the way that the trial court failed to really engage with the evidence that came out at the hearings, you can see that yes, it's about how the court and how the judges are evaluating the evidence, and how they tend to side with what the state is saying without really being a true arbiter of the facts.
You've made several recommendations to improve this law. Today, if it is proven that junk science evidence was presented during the penalty phase, the CCA does not review the case. This junk science evidence must be presented during the trial itself, right?
Yes.
You want to change this approach. Could you explain more about this recommendation and clarify what the penalty phase is?
If we're going to use a death penalty trial as an example, there's going to be the guilt innocence phase, which is where you decide whether the person is guilty or innocent. And then there's a sentencing phase, which in a capital trial is like another trial in itself. And that's where there will be evidence of the person's character presented, previous offenses, could be facts related to mental illness, all those kinds of things that can, and future dangerousness, which then the jury will use to determine whether someone will ultimately get a death sentence or life without parole. And so in the traditional post-conviction application, you can file something that applies to the penalty phase. But when it comes to the junk science law, you can't. So if there's, say, an offense that's presented during the sentencing or penalty phase where there's some unreliable science used to show that somebody committed an offense, you can't present that in an application. And the harm of that is that, these are things that are used to convince juries that someone should get a harsher punishment, the harshest punishment. So we would like to see there be a change, making it clear that this applies to the penalty phase, so that, let's say, the state presents evidence of an other offense and relied on junk science in presenting that the court can grant relief on that and say, no, this shouldn't have been, this would have changed the way the jury would have considered the evidence. And there's a chance that the jury, instead of finding the person, say, a future danger, they might not have, because they wouldn't have been able to rely on that offense at all. So it has very big implications, especially for death penalty cases where you have lots of other, where you have evidence that relates to future dangerousness and other offenses presented to the jury.
And you want to change this, of course.
Yes, it would make the process much more fair and prevent people who shouldn't face a harsher punishment because of faulty science that was used in their case.
You also recommend, and we've talked about it already, that the CCA explains why a claim is dismissed or denied. That's an important thing you want.
Yes, I think it's unlikely for that to happen, but it would be really helpful for guidance for lawyers, for people who are filing applications, to understand how and why the CCA is making its decisions. And looking at the applications and looking at evidentiary hearings and findings, sometimes the outcome that we see from the CCA, it can be difficult to believe because we've seen quite meritorious cases go unreviewed. And so having an explanation of why something is dismissed or denied would be helpful, and would be just and provide transparency in the process.
Since you released your report, have you heard back from representatives, or do you feel it was read by politicians?
Yes, when Robert Roberson had an execution date this past October, legislators actually did ask us to speak on our findings. And at a hearing before legislators, I spoke and talked about the report's findings and how we've seen that 1107-3 wasn't its promise as they believed it would be, that wasn't being fulfilled, and so that was used to support their subpoena of Mr. Roberson, and to have another hearing, the fuller hearing where they went into the facts of Mr. Roberson's case to really probe 1107-3 and particularly how it was applied in this case. So yes, it has been received by legislators, and they've also helped us in helping to explain some of their own beliefs about what the law would be doing.
So you think they will change the law in the future?
I think so. I think that they have seen, especially with Robert Roberson's case, that there are problems with it. They have realized that perhaps some of the language is not directing courts well enough. They've seen the great risk that exists with not clarifying some of the language in the law. And so, yeah, I think that they will make some changes. I don't think it will be easy necessarily. I think they have to balance one, again, like they're trying to balance public safety with actually with access to justice, with making sure that the people who truly deserve a chance are actually getting that, but also not putting a huge burden on courts. And so they have to balance all of that in any amendments or changes that they make. But I do think that they want to, and that they'll have to collaborate to make that happen.
And do you think the CCA itself will change the way it implements the law?
It's hard to say whether the CCA will change to change the way they implement the law. Right now, the CCA, they have, under the Texas Constitution, they have jurisdiction over state habeas cases. And so it's really under their control how they handle the cases, review them, how they issue their opinions. They obviously, over the years, when you look at the opinions, you can see that they are thoughtful about how this law works, and what they think it should do, and we've seen that with past judges, like especially Elsa Alcala, who wrote a lot of opinions on 1107-3 and how it's working or not working, and what the CCA could and could not do to help that. And she's off the court, but even now we still see judges making comments on 1107-3. So whether they will change, I don't know, but I think that they are cognizant of some issues and concerns related to it, and how they're connected to that.
Well, thank you very much for coming here to talk about this work you've done.
Thank you.
Before we go, I really encourage you to watch the film Trial by Fire. It's based on the true story of Cameron Todd Willingham, a case we discussed today, and it brings this issue to life in a powerful way. The movie was released in 2019 and is now available online. If you enjoyed this podcast or YouTube video, please leave a comment, subscribe, and share with others. It's important to keep this conversation going. Thanks for listening. See you next time.